So this is about the ASA, South Africa, to Mars and back. Mars is the Medicines Act, and legal acrobatics. No offense, Janusz. Some disclaimers. I'm a joint appointee at Dr. George Mukhari Academic Hospital and at Sefako Makgatho Health Sciences University, which is a phoenix-like resurrection of Medusa. I'm a council member of the Allied Health Professions Council of South Africa, appointed by the Minister of Health as a community representative, and a member of their professional board for homeopathy, naturopathy, and phytotherapy. So a lot of people question me about this, and they say, how can you hypocritically be part of a council that is seemingly promoting pseudoscience? And the way I've justified it, maybe to myself, is that the Allied Health Professions Council regulates the behavior of these professions which are recognized in law. So I'm not into fighting the law or changing the law or amending the Allied Health Professions Act. But, as I repeatedly point out to the fellow council members and to the professional board members, their use of medicines is subject to the Medicines Act. And then finally, just to say, I'm speaking in my personal capacity and my views are my own. We've heard a bit about the Advertising Standards Authority already. When you submit a complaint, the first thing is are you a consumer or a competitor? So mostly, Harris and I have been consumers, presenting as consumers, or as if we were to buy the product or believe the advertising. One of the big issues in the ASA is that there has to be an independent, credible expert to substantiate a product. And the independent, credible expert is supposed to be from the people who are complained against, and they have to show that the expert is independent. We've had times when the expert wasn't independent, is credible, and is in fact an expert. So those issues come up. Shortly after I first laid a complaint, and it was a successful complaint, I was banned from complaining any further, because at that time I was a member of the Medicines Control Council. Excuse me. And the reason given to me was that the ASA uses the MCC for clarification of complaints, or will escalate a complaint or an issue to the MCC if necessary. In all the years subsequently, I have never ever seen that. While I was on the MCC, there was never a request for clarification or an escalation to the MCC, and subsequently, as far as I know, there hasn't been. The structure of the ASA, the first line where your complaint goes to is the directorate, and then they make a decision as to whether or not the complaint is upheld or dismissed. Their decision can be appealed or arbitration sought. If it's appealed, it can go to the Advertising Standards Committee for Consumer Complaints or the Advertising Industry Tribunal for competitor complaints. And if no joy is received there, you can still take it to the final appeal committee, which is presided over by the president of the ASA, which is historically a former judge, and in the last few years it was Judge King, Judge O'Regan, and Judge Ngwepe. The directorate looks at, is the person substantiating the product an independent, credible expert? As Harris has already alluded to, the industries recruited members of, and I'm calling them tame medical doctors or pharmacists or others, who would provide substantiation and say, yes, I am an expert. I say it works, therefore the advertising is valid. And that was the extent of the substantiation in the early days. There was no application of minds or substantive evidence needed. It was based on the mere say-so of the substantiator or the expert. In later years, the Advertising Industry Tribunal actually challenged the directorate and stated that they must assess the expert substantiation and the expertise of the expert. So there was a shift in power, which was a move from an unquestioning pro-industry stance to a pro-truth, pro-people public stance. And yet, to this day, as far as I know, there is still no recognition of the expert complainant. So your evidence that you may submit for the rationale behind the complaint is not necessarily looked at in the same way. At the time that the MCC abandoned its responsibility, to regulate a variety of substances, increasing numbers of complaints arrived on the ASA's doors, and increasingly the advertisers were ruled against. So this was I'm coming to it again, the 2002 Complementary Medicines call-up, which released, as Harris has already stated, tens of thousands of medicines onto the market without any regulation by the MCC. At that point, when the industry started losing at a greater rate than before, they turned to lawyers rather than experts. And as a result, in the end, the ASA was eventually put under business rescue and only started functioning again recently with the Supreme Court of Appeal ruling and the recruitment of members, new members and old members, and appointment of a CEO. So, the Medicines and Related Substances Act. The greatest error was the 2002 Complementary Medicines call-up. I've put call-up in inverted commas because the title of the call-up in the Government Gazette called it Call-up Notice for Medicines, frequently referred to as complementary medicines in terms of the Medicines Act. But in the notice itself, it said that it was to be a 6-month audit of what was available in the market in 2002. The council members at that time estimated that there might be about 6,000 complementary medicines available on the market. At a later stage, with Dr. Shabalala Msimang and her spokesperson, that figure jumped to about 14,000 products, and then later it jumped to about 20,000 products, and then, as I will show you in a minute, it jumped to over 150,000 products, and that figure was provided by the Minister of Health in a written parliamentary question, and it was dated the 29th of October 2010, and the supplementary question to that was, had any of these medicines been tested for quality, safety, or efficacy, which is the primary mandate of the Medicines Control Council, and the answer was no. So the Minister of Health acknowledged that there were these tens of thousands of medicines on the market, none of which had been checked even for quality, that they contain what they said they contained. I also, at the time of that call-up, received information from the chairperson of the Complementary Medicines Committee, who was my boss when I was at Rhodes University, and that was Professor Izzy Kanfa. And he informed me that after the Complementary Medicines Committee meeting, and I may have misunderstood him slightly, the wording of the call-up was sent to the state lawyers, and they actually changed it so that there may have been some misunderstanding, but I don't think that's an adequate excuse for the chaos that ensued. An unfortunate aspect of this whole thing was that as the industry submitted their responses to the call-up, they received from the Department of Health an acknowledgement of receipt which contained something called a registry number, which meant the number in the registry or in the message room, if you like. So, but the industry misinterpreted that to say registration number, which is a completely different animal altogether. And so, as a result, various perverse uses of that registry number were made. It was even used as a defense in some of the advertising standards authority defenses to complaints, and it was then realized that it was merely an acknowledgement of receipt. The Medicines Control Council, and I'm ashamed because I was a part of it at that time, took no responsibility for the misleading advertising of the products illegitimately, I've put in inverted commas, flooding the market. So there was, as I've said, over 150,000 medicines, no quality, safety, or efficacy determined, and that came from a parliamentary question from the Minister of Health. We don't know how many subsequently came onto the market between 2010 and February this year, when the call-up was eventually rescinded. But in the meantime, I with the help of Harris and others, discovered that one way of getting the MCC to take action was to write an open letter and have it signed by preeminent medical professors and people who were acknowledged leaders in the field of medicine. So then the MCC decided to take notice and to take action. So the call-up was in fact rescinded by the MCC on the 14th of August 2009. That was 8 years ago. But before the minutes had even been circulated of that council meeting, an appeal had already been lodged by the industry in terms of the Medicines Act, which showed you that there were issues with confidentiality and leaking of information from the Department of Health at that time. Eventually, I believe, an agreement was reached between the industry and the MCC that if the MCC didn't rescind the call-up, the industry would not take the MCC to court. To me, that's ultra vires, and it's maybe, and I put the word in soft, in inverted commas, blackmail. Finally, the call-up was rescinded in February this year. Then we had two new acts, the Medicines and Related Substances Act 72 of 2008, which actually included the establishment of the new body called the South African Health Products Regulatory Authority, and focused on products. These products included medicines, scheduled substances, cosmetics, and foodstuffs. I think it also included at that stage medical devices and IVDs, which is in vitro diagnostics. In other words, diagnostics done in the laboratory. That was challenged. And then Bill 6 of 2014, objects of the bill, included the insertion of the definition of a complementary medicine. However, the definition itself was not included in the bill, only the object that it should be included. And it reversed every definition, everywhere where the word product appeared, it was replaced with medicines or medical devices or scheduled substances. And so eventually the result was the Medicines and Related Substances Act 14 of 2015, which deleted product, and every mention of product was replaced by medicine or scheduled substance, and it included medical devices and in vitro diagnostics. The latest amendment of Act 101 of 1965 was promulgated on the 2nd of June this year. As Janusz mentioned, this body replaces the MCC, but it only replaces the MCC once the board has had its first meeting. The board has not yet had its first meeting. It's been appointed, and it is expected that the MCC will have at least one more meeting this year, and that SAPRA will come into being early next year. In the meantime, behind the scenes, the regulations to the Medicines Act defined a complementary medicine, inter alia, in terms of the professions regulated by the Allied Health Professions Act, and included complementary medicines as a new category of medicines for use in humans, category D, as already alluded to. But there was no place in this new definition, or in this definition of a complementary medicine, for dietary supplements. And so the industry, which is predominantly dietary supplement focused, were up in arms and put pressure on somebody somewhere. And the latest regulations now include, as Janusz showed you, this new component of complementary medicines called health supplements. To me, that's a really vague and anomalous term. Do they do anything for health? Are they really supplements? What are they supplementing? So those kinds of questions arise. The 2013 regulations included a staggered call-up for various medicines between 2014 and 2019, and a roadmap was provided by the MCC. It appears with the latest regulations that roadmap has been abandoned. I can't be sure about that though. But then in the meantime as well, while the regulations were as yet not finalized, a lot of work was done on a guideline called Complementary Medicines, Health Supplements, Quality, Safety and Efficacy. And this was the first time a public definition of a health supplement came, but it was mainly dietary, food or nutritional supplements or complements health, quite whatever that means. The latest regulations were published on the 25th of August this year, including complementary medicines and incorporating health supplements. But as Janusz has explained already, excludes injectable preparations and excludes medicines or substances listed as Schedule 1 or higher in the Act. So really, it restricts health supplements to a very tiny part of the market where they really can't do very much. And one of the interesting things about excluding injectable preparations is that allied health professions or allied health professionals are not allowed, in terms of that act, to give injections. So, however, there is a disclaimer, which you were shown, that the advertising for unregistered medicines must include the disclaimer if they've not been assessed. That disclaimer does not seem to be used very much. I've seen it on products, and I've seen it in fine print on television. I've never heard it on a radio. The confounder of all of this, which I've tried to allude to, is that the schedules of medicine, and this is not the schedules of the Act, the schedules of medicines, impose various restrictions on who can prescribe or possess various medicines. For example, the cannabis plant is a Schedule 7 substance, and to obtain permission to use or possess it, you have to get direct permission from the Director General of Health. However, cannabinoids, which are the substances, are Schedule 6. The latest Constitutional Court ruling in this regard is awaited. There was an appearance about 10 days ago. So the legal acrobatics that I referred to. The industry engagement allowed complementary medicines call-up to continue beyond 6 months. I've put by negotiation in question marks as part of my complaint to the public protector at that time in 2010. I was given documentation which included records of the Registrar of Medicines from the time of the 2002 call-up, which showed a meeting in early August 2002, which would have been the cut-off date, would have been late August 2002, where the industry basically negotiated using their own minutes that the Department of Health had agreed not to end the audit. In the meantime, also, the Medicines Control Council declared several medicines undesirable, which is the way in which they are banned in South Africa. One of them was kava, which caused idiosyncratic cases of hepatotoxicity. The idiosyncratic, in this case, means unpredictable, which was why it was banned. And they were sometimes fatal, sometimes required a liver transplant. Simply Slim, as Harris mentioned, was also banned. It contained a Schedule 5 weight loss substance called sibutramine. So it was fantastic. It worked. It worked like a bomb. The only problem was it was being sold by housewives on a peer marketing system, and nobody was checking the blood pressure or other risk factors associated with taking the sibutramine that had to be done, which was why it was a prescription medicine rather than just an over-the-counter. After it was banned, the manufacturers reformulated it and started selling it again. And guess what? It didn't work. The Nordmann Artemisia antimalaria was banned, that ban is now being appealed in the Gauteng North High Court. The medical doctor from UCT who formulated this medicine believes that because it's a traditional medicine, it does not fall under the Medicines Act, or that as a medical practitioner, she has free rein. It is her right to prescribe or formulate or sell or dispense traditional medicines. This is a whole area that we haven't yet looked at properly and will have to be dealt with in years to come, and perhaps there'll be a conference here in a few years' time talking about traditional medicines and science. Okay. What I've noticed happening is that lawyers can avoid addressing the merits of cases, but as is legally permissible, can challenge the process. For example, the big issue with the Advertising Standards Authority was that you can't impose restrictions on non-members. However, that's a slippery slope as well, because as with the Herbex case, when it went to the final appeal committee, and this was Justice Kate O'Regan, she acknowledged that Herbex was not a member of the ASA, but at that time, Herbex was a member of the Health Products Association. The Health Products Association said in its constitution that every member of the HPA must abide by the Advertising Standards Authority. So guess what happened? Herbex resigned from being a member of the Health Products Association and said, we're no longer under this jurisdiction, we're no longer under this issue. And later, the Health Products Association itself resigned from being a member of the Advertising Standards Authority. So thereby removing themselves from the regulatory actions of the Advertising Standards Authority. Except that the Advertising Standards Authority still has authority over its members, which include the print media, the broadcast media, and various other aspects of the media. Lawyers can appeal decisions. This is legitimate. For example, of the MCC, the rescission of the 2009 caller, which I still have concerns about, the negotiated settlement. And the question is, were any members of public harmed in the intervening 8 years? And finally, lawyers can create innuendo. For example, in the Biostrath Final Appeal Committee case, which I was involved in, there was a false accusation by the lawyer of malice against me. I found that extraordinarily offensive. The Final Appeal Committee did not in the end address the misuse of the commercial publication MIMS for substantiation. There's a mistaken belief that MIMS is a reference book for medicines. It's actually a commercial advertising magazine, and particularly the complementary medicines version of MIMS. However, in the Biostrath case, arbitration, which was a separate process, was done by a homeopath, and the homeopath found that none of the disputed claims were valid, which is a very interesting finding. The Matthias Rath case in June 2008, based on the claim that vitamins can cure AIDS. There was the Judge Zondi ruling, which was very important. And then in March this year, the Hugh Brathwaite case. He was marketing a vaginal gel with the claims that it could prevent AIDS and it could prevent conception. And it was ruled against by Judge Makume. And although the MCC had declared the gel undesirable, Brathwaite sued the South African HIV Clinicians Society for publishing an article he considered defamatory, which is why it went to court. Judge Makume found that the gel was a medicine, in fact, and should have been registered. He also ruled that the MCC is the expert body tasked with making such decisions in South Africa, in essence disagreeing with Judge Zondi in the Matthias Rath case. So in summary, the MCC failed to take responsibility for the advertising of unregistered medicines and substances, but in fact facilitated the widespread availability of unproven medicines and substances for 15 years because of the 2002 Complementary Medicines call-up. The ASA was left holding the baby, and their credibility and legality was eventually challenged in court, and the merits of claims made for medicines and substances are at times, probably usually, not addressed in favor of legal processes. The merits are what protects the public. The legal processes protect the industry. So my conclusion is that the merits of claims for medicines should always be determined prior to the legal processes in the public interest or public health interest. Thank you very much.